Welcome to a special episode of The Dissection. And today we are going to be looking at former President Jacob Zuma going back to the Constitutional Court 19 days before elections. Jamie, let's start here. Your reaction to Jabulani Khumalo, who decided to, involve the IEC.
Well, I think that what we saw with the Jabulani Khumalo issue was how sometimes Jacob Zuma is very effective at planning ahead and navigating the political jungle, so to speak. Because if you think about it, Khumalo sent a letter to the IEC saying that, look, I'm stepping down. Zuma is now the leader of the party. Zuma got duly registered by the IEC as the leader of the party. And then, Vamkeeper. So he then thought, I still have power, whatever the case may be. I'm going to write to the IEC. It didn't work. Zuma was steps ahead of him. And he did interviews and he spoke in public talking about that decision. Obviously, the conversation with him was, listen, we need Zuma to be the face of the party because nobody knows you. And that's fair. That's fair for them to say because who knows this guy? And he may have been politically active, but he was not a figure that anyone knew. Did you know him going into this election? If I asked you in June of 2023, do you know Jabulani Khumalo? How many people would have said, no, Nyamazi is a great politician? Zero. So this was an example of just how Zuma has thought several steps ahead. In fact, the whole Contowe-Sizwe journey has shown us that this is something Jacob Zuma has planned very carefully and anticipated very carefully. And he did it in such a way that the first few steps, there were no flashing lights or even, red flags for the ANC to try to block this thing before it came out. And when it came out in December, because it was Christmas, because it was festive, the attitude wasn't that great either. And now we find ourselves in a situation where we've gone to 3 different court processes and there's been an attempt to remove him. And now we're going to a 4th process, which is the Constitutional Court. That's the final boss, main event type of thing. And it's happening so close to the election.
What did you make of the IEC saying Andizi?
Well, I mean, there's nothing that Jabulani Khumalo there was going to succeed with because it's a simple question for them. They've registered. They've registered the man. He's the leader of the party. Only the leader of the party can be communicating with the IEC about who's on the list, who's off the list. They don't involve themselves with the internal politics. And I think, the accusations that he took money from, the Ramaphosa camp or people who really are now trying to use other tactics to remove Zuma, that he bought a car, a Land Cruiser. I don't know. We can't prove that. I mean, they did take a picture of him at a car dealership, but he could have just been looking at cars. There's no way of knowing for certain what he was doing in that dealership or if he's currently driving a Land Cruiser. If you guys have seen him on the road, let me know if he's driving a Land Cruiser. But there's nothing that the IEC could have done. It was a desperate attempt. And what was benefited in some instances were a few headlines. Because then it was a media narrative that there's internal fighting within Umkhonto-we-Sizwe. I mean, there may be some disgruntled people right now because Zuma has been very aggressive in removing people. But I also want to say, you know what? In so much as Zuma has done this, removed a few people. He removed Bonginkosi Kanyile as well, who was all over the place, getting overexcited, saying things that were problematic. At this time, in this kind of an election, you do have to worry about infiltration.
Okay.
You do have to worry about the powers that be trying to get into your organization, derail it. And we saw with Julius Malema, what happened was when the CR documents leaked, there were 2 members of the EFF who had been taking monies. I think they took 80,000 Rand each from President Ramaphosa. And then they had to be expelled from the EFF because the reason why they were taking money from President Ramaphosa was unclear. And what then there was said was that, no, I gave them this money out of generosity or it was for funerals and stuff.
I remember that.
But the time when they started taking the money was 2017, right around the CR17 campaign.
Gotcha.
So it may very well be fair to conclude that the EFF had been infiltrated, by people who eventually became MPs. So you have to watch out for this. Part of what derailed COPE was internal infiltration saboteurs, agent provocateurs were in COPE to make sure that COPE wouldn't make it. And Zuma would be aware of that because he was there dealing with COPE. So he would know how these dynamics work. And you have to remove people who are not fully in alignment or who could be risks down the road. It looks like that's what he did.
Yeah, and Jamie said it here on the dissection that it's election season, so you must put your skepticism spectacles
You
on.
must. Hey, everything that's happening now, you gotta.
IEC versus Jacob Zuma and the MK. How significant is that considering that it's happening 19 days away from elections?
From a political perspective, this is a great moment for Jacob Zuma and the MK party because it's another political rally. It's another political event in a forum that he has been able to argue quite aggressively is against him. So it's a good moment. It feeds into the narrative that there are forces that are trying to remove Zuma from the ballot by any means necessary. This is something that, from a political perspective, very, very useful for Umkhonto we Sizwe and Jacob Zuma.
Free media attention?
Definitely. And that's called earned media. There will be every media house tomorrow focused on this case. Or if you're watching this in the morning, later today, there'll be every media house, every journalist, senior journalist. It's one of the main events of this election going to where we're going because going to the significance question is quite high. If the court rules that Zuma cannot be on the ballot, and that is not eligible to be on the National Assembly, this could affect the performance of MK. One of the reasons why Zuma fought for this particular thing is because it makes it more real if he is going to be number one on the ballot. He's the face there on the ballot. You know he's the leader. You know he's going to the National Assembly. He's going to be calling the shots. It makes it more real. If you remove him, some people are going to be like, well, how's it going to work? And all of those technical questions can create an enthusiasm gap.
Yeah.
But to be quite honest, even if he gets removed, COPE is a political project that was backed by Thabo Mbeki. He was never on the ballot, but we still know that COPE was able to get 7%, even with Mbeki not being on the ballot. So, even in the case where he loses, the losses may not be that significant because now Umkhonto we Sizwe is a thing. In January, it was a question mark. Now it's a thing. Now it has real supporters. And I can tell you what a political leader from another party said. She said whenever she's on the ground, she always sees Umkhonto we Sizwe people on the ground working.
Can I tell you something? After we shot last week's episode, I saw them.
You saw them. So that's the deal. They're working, they're on the ground. But the significance is quite great. And it's great on two sides, right?
Sure.
If they win, it's a big moment for Zuma, Umkhonto we Sizwe, and it's a big blow again for the ANC.
Right.
But if they lose, there's also a risk of chaos, drama, and I don't wish it. I always wish for every election to be peaceful, non-violent. I wish for even the posters that are being taken down to not be taken down. Political violence is an ugly Pandora's box that you never want to open.
Yeah.
But there's a potential because we saw this in 2021. We saw what happened when people felt that Jacob Zuma was wrongly treated by the courts and wrongly sentenced. We saw that 356 lives were lost, billions were lost, business was disrupted, and some businesses are still recovering to this day as a result of everything that happened.
People lost jobs and they never got them back. Yeah.
So this is not a joke thing. It's a very serious case with very serious implications. And because of that, I actually think that the Constitutional Court should not have taken this case on an urgent basis. I think that some of the elements of this case are matters of law which can be settled without urgency and understood for a future election.
Okay.
Because this is not something that is being contested by 50 criminals or 50 people with criminal... It's.
So are you saying the Concord could have waited?
Yes. I mean, the Concord hasn't released a judgment this whole year. For this to be the judgment that they get their socks together on is something that I think can lend to perceptions that they're over interested in Zuma and not as interested in others, right? So I don't think that they should have taken this issue on an urgent basis, in my opinion. I think that they should have kicked the ball down the road, allow people to vote, because you don't want to have a situation where court is perceived to be meddling with an election or, trying to tilt the scales in favor of one person over another, right? So that's something that's significant. And there was a big court case in America after an election where George Bush and Al Gore argued about who won because there were issues with the counting. And the court ended up ruling with George Bush, and it affected that election result, whereas many people question the veracity of that decision and whether or not George Bush actually should have won, right? And it's something that can become a problem and something that can undermine the credibility of the system and all of the institutions around it. Okay, so going into the case in and of itself, right? The first thing that is going to happen, and that is critical here, is the reclusion application, right? You can apply for reclusion if you have reasonable apprehension of bias. The test for this thing is that, one, the apprehension of bias must be that of a reasonable person in the position of the litigant, and it must be based on reasonable grounds. So the case law for this, which creates this precedent and these standards and the test, is President of South Africa and others versus South African Rugby Union and others. This is where the case, the principles got distilled.
Okay.
So again, you need to show that you have a reasonable apprehension of bias, but from the reasonable person standard, right? A reasonable person is a legal standard in and of itself. And then you need to show that it's based on reasonable grounds. So that's going to be the first argument. And Zuma's lawyers are going to argue that because the Constitutional Court has many of the judges who wrote the first judgment, which created this 15-month sentence for Jacob Zuma, those judges should recluse themselves. The technical element of that is that if those judges recluse themselves, then you no longer have enough judges for there to be a quorum in order to hear this case. So Zuma likes to test the system like this. Every time Zuma has a case, he's not going to just go and argue. He's also going to try to see what he can throw in terms of into the gears of the system in and of itself. And this is that. But he's justified to do that. He's a person who, if he thinks there's a reasonable apprehension of bias, has to explore whether or not there's a reasonable apprehension of bias. And if you look at some of the stuff that the court said in the Secretary versus Zuma, right? This is basically what they said in that case, the one that ended up leading to his arrest. At paragraph 47, a coercive order gives the respondent opportunity to avoid imprisonment by complying with the original order and desisting from the offensive conduct. Such an order is made primarily to ensure the effectiveness of the original order by bringing about compliance. A final characteristic is that it only incidentally vindicates the authority of the court that has been disobeyed. This is them saying this is the purpose of a coercive order versus a punitive order, right? Right? But they then say a coercive order would be futile and inappropriate in these circumstances, right? Because it is incontrovertible that Mr. Zuma has no intention of attending the commission, right? Having repeatedly reiterated that he would rather be committed to imprisonment than cooperate with the commission. Then they further say, Mr. Zuma demonstrated a marked disregard for the authority of this court in his resolute refusal to participate in the commission's proceedings. Thus, it is impossible to see that a coercive order would achieve any of the purposes of the contempt proceedings, right? So what they're showing here is that they already have a presumption about the character and the man, Jacob Zuma, to the point that they can say, we're no longer even going to bother with following the steps. Because this guy, uyadelela. That's what they're saying.
And that's problematic.
That's problematic because how can I go to people who are saying uyadelela and expect a fair hearing?
Yeah.
Do you understand?
Yeah.
And even here, if you look at what they said, paragraph 57, I acknowledge that the decision at which I arrive, namely an order of direct committal, may constitute an unprecedented step forward in the trajectory of contempt litigation. When someone says, I'm doing something that is unprecedented, In law, that means I do not have the legal support to back up this decision. I'm now going into uncharted areas. Para 57, I acknowledge that the decision at which I arrive, namely an order of direct committal, may constitute an unprecedented step forward. Right? And then, no, para 58.
58, yeah.
Although I acknowledge that for the most part, our jurisprudence has left me up the creek without a paddle, I must say it is perilous to rely on irrelevant precedent. So she was talking now about what Theron J. and Jafta Day said, that, hey, listen, there's precedent which actually is against you. And then she said, no, it's irrelevant. We don't care about that precedent. That's worrying, right? If you are Zuma. That's worrying if you are Zuma. So he has, I think, some fair grounds to make this particular complaint, and we'll see if he succeeds. I don't think that they will recluse themselves. I think that they will say, no, we're not biased. Let's go, let's do this, right? And then the questions then become, what then must the court determine? There are 5 things that that informed the IEC decision when they made their decision, just to reiterate them so that everyone knows what they are.
Sure.
They are as follows. There were 5 issues that the court had to decide upon, right? Number 1, hold on, I need to just hold on, let me find my notes here. Take notes here, we're not just doing this thing mahala. Okay, go before.
Did you highlight them or underline them?
Yes, here they are, here they are.
Okay.
So they need to determine, number 1, whether the commission lacked the authority to make the determination under Section 47 of the Constitution. Because recall, it was argued by the lawyers for Zuma, Advocate Dalimpofu SC, that actually this is not the work of the commission, this is the work of the National Assembly that should be able to make this decision. That's number 1. Then number 2, they have to determine the question of whether the commissioner and Commissioner Love were biased, right? Because remember, she made some statements earlier, right, about the status of Zuma in January.
Right.
And even though she reclused herself, there's a question around, did she taint the process as being a senior person at that level, making those determinations?
Yeah. And she's still at the IEC.
Yes, and then whether Zuma was convicted as contemplated in Section 47(1)(e). So the section says that you should not have been convicted for a sentence of longer than 12 months, right? But because, and this is where the judges were at, they said, listen, this applies typically to a person who has right of appeal, right, and is able to go through the legal system at every level to appeal and then to get a final determination of this issue. But Zuma was not able to get that determination. And as such, there's a question of interpretation which falls into this case, right? And then there's going to be a determination on what is the right interpretation and a development perhaps of the understanding of interpretation of law. Right now, the case for interpretation, the leading case is M. Dumeni. And this case speaks about the historic standards for interpretation, but it emphasizes that context is key to understanding the interpretation of law. But this is going to be one of the things that the Constitutional Court will then have to consider.
What's the 4th thing?
The 4th thing is that whether there's a legal effect of presidential remission of sentence on the sentence imposed on Zuma. And we're going to be hearing arguments around, because the remission happened, right? As a result of that remission, the sentence can no longer be considered to be 15 months. It must be considered to be the 3 months that were served.
Right.
And then also, and whether the sentence imposed on Zuma, the sentence itself, is a sentence that can be interpreted as a sentence as contemplated by. So remember, there's the issues of the actual. Let's go back so that we understand the distinction.
Okay.
Did I go too far? I think I went too far. Oops.
So we have to go back to number 4.
Right. Number 4.
Isn't it this
No,
one?
not the remission. Number 3.
Number 3, okay.
Whether Mr. Zuma was convicted as contemplated in the section.
Okay.
And then whether he was sentenced as contemplated, because it's those two things are different, and we're going to be hearing arguments around that, right? And interpretation of law around that. So those are the 5 issues. And so what we're going to see are arguments about recusal, arguments about jurisdiction, arguments about interpretation. And this is going to be something that I think brings this issue full circle. Because if you recall, the decision comes from this court, but it always had some questions because, and I was one of the people who asked this question, the decision to take Zuma by the commission to the Constitutional Court as the court of first instance was irregular. And it's the decision that created this anomaly. Number two, the decision to skip the coercive order was not in the interest of the State Capture Commission. It was not in the interest of finding out what happened with state capture. And this is what created this constitutional anomaly. As the judges said, listen, we are operating outside of precedent. And as the dissenting judgment said, you're violating Zuma's constitutional rights. Number three, the court presumed certain conduct from Zuma in coming up with this sentence. And that's something that we must have an honest conversation about. And finally, the public interests were not considered in seeking to show, right, the power of the court, the authority of the court. The general public interest was not considered, and this is what created the mayhem that we saw. So the court is in a very precarious position because people are concerned. People are concerned that Chief Justice Raymond Zondo used the State Capture Commission for promotion. They're concerned because they saw many things. They saw this. They saw him being very nice to President Ramaphosa during the hearings. They saw him strategically releasing the State Capture Commission reports in part 1, part 2, to almost put pressure on the president to pick him. Because remember, he was not picked by the JSC.
Yeah, wasn't recommended.
He was not recommended. They didn't want him, right? So he ultimately got picked. And there are some people who will have a view that he was picked because he created a favorable environment for the person who was going to pick him. Because this is a conflict that we need to address and be explicit about. Challenges arise when people who are investigating and adjudicating upon someone are also in interview processes to be promoted by that same person. Same thing happened in the State Capture Commission. So why I'm mentioning this is because if these things are not dealt with the level of scrutiny, with the level of due diligence and a level of real honesty about public sentiment, this can undermine the credibility of the court. This can undermine the trust that the public has. But I want to say one last thing, and I think we're running out of time.
Sure.
We must stop allowing people to silence us when we question or examine institutions. Right? We examine the executive. We examine the legislature.
We examine the judiciary.
We must examine the judiciary. Yeah. There is no institution which we must make like it's holy. That's cult behavior. In a democracy, in a free democracy, people should be able to apply their minds, express their concerns, right? And just to show that these concerns are not illegitimate, in America, people acknowledge that the Supreme Court right now is right-wing because Donald Trump appointed right-wing judges. People know that the courts in New York are aggressive towards Trump, while the courts in Florida are favorable to Trump, right? People know that in African dictatorships such as Zimbabwe, the ZANU-PF gets favorable rulings. Robert Mugabe lost some cases in the early 2000s, and he took a very drastic step against the courts. And eventually the judges and the courts started ruling in his favor because of his undue influence on them, right? So if we can see that, hey, in America, courts can lean one direction or another due to the influence of policymakers and people who appointed them. If we can see that, hey, in New York, the judges can be harsh on Trump, in Florida, they can be soft on Trump, that indicates that the system is not perfect, that the system requires scrutiny. So if we can even see it for Zimbabwe, for Uganda, we must not create this narrative that it does not have potential to exist even in South Africa. We saw the media telling us that Judge John Tlhope, operated outside his powers in a manner that was corrupt. He was the Western Cape Judge President. So we acknowledge through the example of John Tlhope that judges can and sometimes are operating outside the ambits of their powers. So if we can see that for him, why do we assume that he is the exception? That he is the only one who leaned into his biases, that he's the only one who recognized the amount of power that he has and used that power to try to influence things one way or another. I mean, I'm not saying that those accusations are necessarily true, but we know that decisions have been taken against him and rulings have been made. So if it's true for him, we cannot operate outside thinking that these other guys are perfect. We must always assume that everyone in an institution of power deserves robust scrutiny at all times, and especially at times of transition of power, such as elections. That scrutiny must be increased, not decreased.
Right. And scrutiny doesn't mean attack.
Yes.
These offices and these spaces are occupied by human beings,
Yes.
and therefore it means mistakes.
Human beings fart and they make mistakes. All of them. There's no exceptions, from Obama to Rihanna. It's
On that note, let us know what your thoughts are in the comment section. Remember to share. Would absolutely love to hear from you. See you soon.